Good afternoon, good morning, everybody. You already heard our introduction. My name is Ingeborg Schwenzer, and I will be chairing this tribunal. I hereby open the hearing in LCIA arbitration number 1982, Hydro N versus Turbina Energia. Claimant is represented by Pittsburgh University, and respondent is represented by Royal Institute of Colombo. My co-arbitrators also already introduced themselves. So I would like to give you some information because my co-arbitrators and I, we discussed the procedure already yesterday. And we wanted to suggest to you that we follow the following procedure for presentation of the arguments. Respondent will start on issue 1, the question of jurisdiction of this tribunal, followed by claimant, followed by a rebuttal by respondent and a short rebuttal by claimant. Then claimant will continue on issue 2, the question of the expert witness, followed by respondent, and again claimant will have the possibility to rebut, and then a rebuttal by respondent. And as regards the discussion of the merits of the case, claimant will start and argue issue 3 and 4, followed by respondent arguing the same issues, and then claimant will have a rebuttal and respondent a rebuttal. And this tribunal asks counsel for both parties whether you do have any objections to this proceeding.
We are not members of the tribunal. For those rebuttals, for the procedural issues, will those be 30 seconds each?
Well, this is up to you. That would be my next question. How the council want to allocate their time to issue 1, issue 2, the rebuttal and the rebuttal. So that will be up to you. But could you agree that we start with issue 1, respondent, and then issue 2, claimant would start?
Yes, we agree.
Yes, Madam Arbitrator. May we briefly discuss the allocation of time?
Sure.
Thank you.
Have you decided on the allocation of time, claimant, counsel for claimant?
Yes, Madam Presiding Arbitrator.
Please.
Claimant would like to allocate 9 minutes to the first procedural issue and allocate 5 minutes to the second procedural issue. And then reserve 30 seconds for rebuttal and rebuttal.
Thank you very much. How about counsel for respondent?
The respondent would allocate the same time limits for both procedural issues.
Thank you very much. Then it is agreed 9 minutes, 5 minutes, and 30 seconds for rebuttal, rebuttal on each issue. Then we will start with respondent and the first issue on procedure. Please, the floor is yours, counsel for respondent.
Members of the tribunal, good morning, good afternoon, good evening, in whichever time you may be today. My name is Daria Azim, and I will be representing the respondent, Turbina Energia, in today's proceedings. Members of the tribunal, the dispute resolution clause before us today is very much like a Trojan horse in its effect. On the surface, while it is seemingly harmless, when opened and analyzed, is quite detrimental, as I will prove to you in my submissions today, which is why we are before this tribunal to ask that our client's right to equal treatment is upheld, and secondly, we respectfully order the exclusion of Professor John. Members of the tribunal, if you would like to follow me to page 13 of this record. We see under Article 21, the dispute resolution clause, that is asymmetric in nature for the following reasons. Article 21(1), in its relevant part, gives the courts of Mediterranean exclusive jurisdiction. However, my client's right to invoke this litigation clause is subject to the claimant's asymmetric right to invoke arbitration by virtue of Article 21(2). With regards to the applicable laws, members of the tribunal, if we look to the latter part of Article 21, we see that it is governed in twofold. Firstly, the procedural aspect is governed by Danubian arbitration law, which is the lex arbitrii of the sea. And secondly, the substantive aspect is governed by Danubian contract law, as it is the substantive law of the contract. Members of the tribunal, I will therefore analyze the invalidity of this arbitration agreement under both of these applicable laws. Moving on to my first submission. This arbitration agreement violates Article 18 of Danubian arbitration law. Members of the tribunal, if we look to the judgment in the case of Front Row Investment Holdings versus Front Row Investment Holdings, we see that they held that an arbitration agreement can only be held valid if it does not...
Excuse me, counsel, can you please give me some details regarding this judgment? Which court decided, what was the clause about? Was it comparable to the clause we have at hand here?
Madam Presiding Arbitrator, this case was heard in the High Court of Singapore in the year of 2010, and we see that the asymmetric clause in that instance, the court held that because one party had the unilateral right to infringe on the opposing party's right to access choice at a forum, we see that they held that an arbitration agreement can only be held valid if the principle of equal treatment enshrined in Article 18 of model law is not being violated. Now, while we understand that the wording of Article 18 prima facie may seem to apply to the conduct of arbitral proceedings, we do not see this as the case because it must apply as an overarching principle to the negotiation and conclusion of this arbitration agreement. We see the intention behind this through the working group in their fourth session. Paragraph 62 of their working paper states that the scope of Article 18 can extend to the negotiations and extend to all procedural agreements. Members of the tribunal, the arbitration agreement before us today is in fact a procedural agreement, and Article 18 must extend.
Sorry, counsel, before you go on, could I just clarify 2 points, if I may? The first, am I right in understanding that the parties voluntarily entered into this arbitration agreement without going into the full gambit of the negotiations? That's the first thing. And the second thing is, for the purposes of understanding the comparison between the case you just cited and the present case, are we suggesting that Danubian law, which as you've just proposed governs both the substance and the proceedings, would come to the same conclusion, or is there some vagueness about the position under Danubian law?
Mr. Arbitrator, I will answer your questions in turn. Firstly, although we do concede to the fact that the parties agreed to this asymmetric arbitration agreement, the fact remains that it is invalid under the applicable laws it was concluded under. With regards to your second question, Mr. Arbitrator, Danubia's stance on asymmetric arbitration agreements is unclear, as there has been no precedent. However, if we were to apply the rationale of Article 18 and the intention behind it, we see that Danubian courts would likely hold this arbitration agreement to be invalid, as they consider equal treatment to be a part of their public policy. If we look at the actual inequality of this clause, members of the tribunal, we see it on two levels. Firstly, if we look at a practical application of this clause, not only can my client not invoke arbitration, but any attempt by my client to apply to the state courts of Mediterranean could easily be circumvented by the claimant if they were to apply for a stay of proceedings. As we see that there is no time bar on this dispute resolution clause, we see that if Mediterranean courts grant the stay of proceedings and the claimant is not compelled to initiate arbitration, my client will be held in a position of limbo where they would not have access to either courts or arbitration. With regards to if I were to submit to this tribunal a case where they did in fact uphold the validity of an arbitration agreement, and if I may refer the tribunal to the case of Dynajet versus Wilson Taylor, heard by the Singapore Court of Appeal in 2017, we see that the ratio in that case may not be applicable to the one at hand because the clause in Dynajet did not contain the words subject to that we see in our clause today. It is therefore a submission that these words subject to is the asymmetric defect in this arbitration agreement and must be invalidated on that basis. The second inequality that this clause proposes members of the tribunal is with the ability to choose a forum comes with it its advantages and disadvantages. Now, if we look at why the claimant wants to deny my client the right to access Mediterranean courts, the answer can be found on page 42 of this record, and if the tribunal would like to follow me there. Through the last 4 lines of this page, what we see is the Mediterranean court's stance on the issue of nonconformity. They require an actual proof of nonconformity, which requires an elevated standard of burden of proof for the claimant, which is why they have manipulated these proceedings and cornered my client into this arbitral proceedings. Members of the tribunal, that brings me to my second submission regarding the violation of Article 3.2.7 of the UNIDROIT principles. Members of the tribunal...
Counsel, may I ask you a question? The CISG governs the substance of the contract. Why don't you apply the CISG?
Madam Presiding Arbitrator, although the CISG is part of the substantive law of Danubia, by virtue of Article 4 of the CISG, it does not concern or govern matters of validity. We must therefore supplement this through the Danubian contract law, which is the UNIDROIT principles. And if we look to the very clear wording of Article 3.2.7, it sets out 2 requirements for its invocation. Firstly, there must have been an excessive advantage, and secondly, it must have been taken in an unjustifiable manner. With regards to the excessive advantage, members of the tribunal, we see that because of the reason that my client cannot access Mediterranean courts and cannot invoke arbitration, this constitutes an excessive advantage as my client's rights are contingent on the claimant's choice. With regards
to counsel, we all know that this clause has been negotiated and there was a quid pro quo. Your client received other favorable clauses like the limitation of liability clause. So how can this lead to a gross disparity?
Madam Presiding Arbitrator, before I answer your question, if I could request an additional minute to answer and conclude my issue on this procedural issue.
Yes, please.
Thank you. Madam Presiding Arbitrator, if we look at the negotiation process of this arbitration agreement, we see that that too was one-sided because the first draft that was included by the claimant was asymmetric in nature. And any proposal that was put forward by my client to agree on a balanced arbitration clause was rejected. And with regards to how the negotiation process was unfairly conducted, there was a disparity between the bargaining powers of the parties because if we look to Article 3.2.7, Clause 1, Subclause A, it states that a party may in fact have an taken advantage of the other party's dependence. In this particular case, members of the tribunal, we must look at the claimant's standings. They have an annual turnover of $4.3 billion US, which is higher than the gross domestic product of countries such as Bhutan. And my client considered this contract crucial because of the fact that we did in fact want to contract with the claimant, and therefore we were left with no choice but to accept this asymmetric arbitration agreement. And with that, we see that the requirements for gross disparity have in fact been satisfied. And as I see, I am running short on my allocated time limit. I would like to conclude by stating that this arbitration agreement violates both of its applicable laws and must be held invalid. Thank you.
Thank you very much, counsel. I want to ask my 2 co-arbitrators whether they have any questions for counsel for respondent.
I have a very quick question, if I may, Madam Chair. It's this, well, they're 2, but rolled together. The first is, do I understand the respondents would be content to find themselves in the courts defending this particular claim? And linked to that, do they consider that, at least under this tribunal now it's constituted and they've nominated their arbitrator, that they will be receiving fair and equal treatment in the resolution of this dispute, having come to arbitration now?
Mr. Arbitrator, is your question referring to the courts of Mediterranean?
It's referring to the courts of Mediterranean, yes, indeed. So clause 1 of Article 21 of the contract.
Mr. Arbitrator, while my client would be happy to go to the courts of Mediterranean, our contention is that this arbitration agreement must be invalidated because it is asymmetric in nature. And with regards to your second question, Mr. Arbitrator, if you could rephrase it.
It's simply to ask the question as to whether you feel that what you say is unequal treatment of the parties extends to the process that's been embarked upon now. In other words, you sit before the tribunal here and presumably you're anticipating fair and equal treatment from this tribunal under the LCI rules, albeit it's not the forum where you wish to find yourselves.
Mr. Arbitrator, to answer your question, we do not find any contention with the application of Article 18 on the validity of this arbitration agreement in the current proceedings. However, we find that our right would be infringed with regards to the inclusion of Professor John.
Very good, thank you.
Thank you very much. If there are no further questions by my two co-arbitrators, then I'll give the floor to counsel for claimant, please.
Thank you, Madam Presiding Arbitrator. Good day, members of the tribunal. My name is David Zweer, and along with co-counsel Tarek Malouf, I represent claimant Hydro EN in today's proceedings. Claimant has brought proceedings against respondent because claimant contracted for and paid a premium price for turbines that would deliver a steady and certain supply of renewable energy. Respondent failed to fulfill its end of the bargain and delivered non-conforming turbines. Claimant has brought proceedings to this tribunal because claimant contracted for the right to do so. And respondent is again trying to avoid its end of the contract by challenging the jurisdiction. I will address the first procedural issue and address the two potential bases for invalidity raised by respondent. Respondent first raised the grounds for invalidity under UNCITRAL Model Law Article 18, which is the procedural law applicable to these proceedings. As an initial matter, I would note that UNCITRAL Model Law Article 18 applies to equal treatment of the parties within the arbitral proceedings, which, as claimant noted, respondent noted, they believe they will receive and have received thus far by this tribunal and received equal right on their submissions, their written submissions thus far. Moreover, Article 18 is found in the Chapter 5 of the UNCITRAL Model Law, which relates to the conduct of the proceedings, as opposed to Chapter 4, which relates to the jurisdiction of the arbitral tribunal. And we see from scholarly commentary that Article 18 works in tandem with Article 19 of the UNCITRAL Model Law, which states that the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. This is the bedrock of international commercial arbitration, party autonomy to craft procedural, how the arbitral proceedings will meet the specific needs of each party. And the parties here did so. I would further point that in regards to the cases raised by respondent, that it is unsettled in Danubia, the seat of arbitration, whether or not asymmetrical arbitration agreements are valid or invalid. Respondent pointed to the Siemens-Dutco case and the Danubian Court of Appeals. However, that case involved a party's right. In that case, 3 parties were forced to choose one arbitrator amongst them. Here, and that is a procedural right within the arbitral proceedings, as opposed to something that occurred on a contractual basis by the parties prior to even the initiation of the proceedings. Thus, I would distinguish the Danubian Court of Appeals. In fact, in claimant's home court of Mediterranean, asymmetrical arbitration agreements are valid, and in respondent's home court, they're invalid. So that reflects how courts around the world have considered asymmetrical arbitration and jurisdiction agreements.
Counsel, I'm sorry, can I just intervene very briefly? Could you tell me, if you know the answer to this, why your client rather complicated matters by having an asymmetric clause in the first instance? You're here, you brought an arbitration, you thought about the likely disputes that would arise. There is a provision for arbitration. Why would you have had, in any event, the option, the exclusive right to go to the courts? What was the purpose of that? To gain advantage, clearly?
Mr. Arbitrator, to answer your question, yes. Claimant bargained for, contracted for this advantage, and they did so. We see from page 47 of the record, paragraph 2, that they did so because, and paragraph 2 and paragraph 1, because they're a company that operates successful hydropower plants in over 100 countries with a myriad of suppliers as well as service providers. Thus, claimant in its operations includes this type of dispute resolution clause as a standard clause because it faces the issues of bringing proceedings in multiple jurisdictions and needs to be able to find certainty and be able to conduct proceedings that meet the needs of a specific circumstances. So it states in paragraph 2, line 4, that claimant considers a certain publicity of the dispute to be in its interest, in particular to put some pressure on suppliers which normally do not want to discuss the defects of their products in open court. At the same time, claimant wants to maintain the option to go to arbitration if it has an interest in confidentiality or perceived other advantages of arbitration outweigh the benefits of court proceedings in a particular dispute.
Counsel, a candid reply, and forgive me, I don't want to intervene too much more on this, but having stated expressly that this is for the purposes of achieving an advantage for the claimant in this matter, an advantage denotes, to some extent at least, an inequality, as it were. I leave it there. It's not a matter that you necessarily have to develop, but it is acknowledged that this is for the purpose of one party having an advantage over the other, at least in the contract phase.
Indeed, Mr. Arbitrator, claimant contracted for this advantage.
Yeah.
And this, although, as a respondent aptly noted, the language of this provision was submitted by claimant and was not changed. What we find in Article 21 of the sales agreement is the clause submitted by claimant. However, we know that the parties engaged in trade-offs on this matter. We know from page 32 of the record that claimant received what they found was a crucial limitation in regard to this negotiation. It states, this is...
Counsel, may I shortly interrupt you? It seems clear to me that this might be dealt with under the question of gross disparity, but does it change anything about the inequality issue? If it was a trade-off?
Madam Arbitrator, may I ask you to clarify your question?
Well, you're arguing that there was a trade-off, that respondent received the limitation of liability clause in return. So in my view, this might indeed affect the question of a gross disparity, but does it affect the question of inequality of this clause?
Madam Arbitrator, it is respondent's position, and I will address the question of gross disparity in a moment, but it is respondent's submission that the question of the basis, the legal basis raised by respondent for procedural equality is something that is just that, procedural equality within the arbitral proceedings. As stated by the English High Court in Mauritius Commercial Bank v. Hestia Holdings, equal access to justice is directed at access to justice within the forum chosen by the parties, not choice of forum. And although England is not a model law jurisdiction, Article 33 of the English Arbitration Act is nearly identical to Article 18. Thus, this should be an influential decision on this tribunal's decision. And respondent also pointed to Dynajet, case of the Singapore High Court of Appeals in 2017, and stated that that case was distinguishable because there was no subject to in that clause. However, it is unclear how that is precisely distinguishable because in that situation, there was, as far as respondent is aware, or claimant is aware, no right to go to court proceedings, and only one party had the right to initiate arbitration proceedings. And we still have the court saying that the fact that only one party gets to choose how the dispute should be resolved is not inconsistent with the meaning or nature of an arbitration agreement. Thus, under procedural law, this arbitration agreement is not invalid. Turning to the second submission by respondent on the matter of substantive invalidity and gross disparity, we see, and I see that my time is nearing an end. May I ask for additional time to address gross disparity, Madam Presiding Arbitrator?
Yes, please. 1 minute, like counsel for respondent.
Thank you, Madam Presiding Arbitrator. Gross disparity states that, requires that, as respondent pointed out, both an excessive advantage and an unjustifiable advantage. And what is required, the comments to the Unidraw principles describe for an excessive advantage is a disequilibrium in the circumstances so great as to shock the conscience of a reasonable person. The trade-offs between the parties do not reflect such a standard. And on the matter of unjustifiable advantage, indeed, there is a disparity between the size of the companies. However, the comments state that superior bargaining power due to market conditions alone is not sufficient, and that a party has to have taken unfair advantage of the first party's dependence, economic distress, urgent needs, ignorance, or inexperience. That is not present here, and thus this tribunal should find both under procedural law and under substantive law that this arbitration agreement is valid. Thank you.
Thank you very much, counsel. Any questions by my co-arbitrators?
No, thank you, Madam Chair.
I would like to come back to the Singaporean case. When I understood you correctly, you said the Singaporean case is distinguishable, and or it's not distinguishable in your view. Could you elaborate a little bit on that? Because we heard from the other side, it is distinguishable.
Yes, Mr. Arbitrator. It is not distinguishable to the extent raised by respondent, because there, although the words subject to were not found in that dispute resolution clause, it states the dispute resolution clause in that case stated that if no amicable settlement is reached through discussions, at the election of Dynajet, the dispute may be referred to and personally settled by means of arbitral proceedings conducted under English law and held in Singapore. Although the precise words subject to are not present, the words at the election of Dynajet are very analogous, Mr. Arbitrator.
Okay, thanks.
Any further question? Adrian?
No, not from me, thank you.
Thank you very much. If there are no further questions, counsel for respondent, you have the possibility to rebut these arguments.
Members of the tribunal, I have one point of rebuttal for you today. My opposing counsel doesn't seem to see the distinguishable features in the case of Dynajet. However, I present two to you. Firstly, the Dynajet case did not have a litigation clause, although the arbitration agreement was asymmetric in nature. In our present case, we see that we do have a litigation clause, and any attempt by my client to invoke it is subject to the asymmetric arbitration clause controlled by the claimant, which makes it a fundamental infringement on my client's right to equal treatment. Thank you.
Could I just follow up on that one for a second? Isn't that even worse? If you don't have a right to go to court at all, isn't that even worse in the Singaporean case? And here you have at least the possibility to initiate proceedings.
Mr. Arbitrator, while on the surface that may seem to be the case, what's worse is applying to the courts and then being denied the right to hear your case in that particular court, which is exactly what we see in the present case today.
Okay.
Thank you very much. Counsel for claimant, anything on rebuttal?
Yes, Madam Presiding Arbitrator. Contrary to what has been framed by respondent, claimant contracted for the rights to initiate arbitral proceedings, and the dispute before this tribunal was initiated by claimant. There is no question here that respondent could have initiated dispute resolution proceedings in the courts of Mediterranean. They chose not to do so. Thus, this hypothetical question of unequal treatment is not even squarely before this tribunal. Thank you.
Thank you very much. Are there any further questions by my two co-arbitrators?
None from me, thank you.
Not from me.
Thank you very much. Then we turn to issue 2 and counsel for claimant. You have the floor, please.
Thank you, Madam Presiding Arbitrator. This tribunal should exercise its discretion under the LCA rules and exclude Professor John because allowing his testimony in creates a risk of a conflict of interest and a challenge with arbitrator burden, and thus under LCA rules 14.42 creates a risk to the efficiencies and finality of this proceeding. I will address two issues with the introduction of Professor John. First, that the probative value and materiality of Professor John's testimony is low, and second, that address why there is a conflict of interest with Professor Burden that should lead this tribunal to exercise its discretion to exclude Professor John. As an initial
Counsel, may I first ask you, do we have the power to exclude Professor John?
Yes, Madam Presiding Arbitrator. LCA Rules 20.3 provide that this tribunal may allow, refuse, or limit written and oral testimony of witnesses, whether witnesses of fact or expert witnesses. Thus, it is squarely within this tribunal's power and discretion to do so.
Counsel, forgive me for stepping in on that precise point. Looking at 20.3, it talks about allowing, refusing, or limiting the testimony of a witness. Does that amount to a power to exclude the witness in the first instance? One could imagine, for example, that a witness puts in testimony part or all of which the tribunal considers to be irrelevant or for some reason inadmissible. But that does it, or perhaps I should rephrase that, does that amount to a power to exclude the expert herself or himself?
Yes, Mr. Arbitrator. The fact that you are correct that this tribunal may limit his testimony, and that is one of the powers that it has. However, the language which speaks to the ability to refuse or allow testimony does provide it the power to exclude in its entirety that testimony.
Testimony, but not the individual. I don't mean to be pedantic, but what comes to my mind is why, in that case, the LCA rules, which are absolutely clear, for example, on the comparable power to exclude counsel, were not similarly clear in an express provision of the power to exclude other representatives of the parties, rather other members of the party's team.
Yes, Mr. Arbitrator. The LCA rules are clear in 18.4 on the tribunal's power to exclude counsel, and that perhaps should be extended by analogy here. Although this tribunal may well be the first tribunal to take such a measure, it is claimant's position that that measure would be merited here, because the LCA rules in a 2015 bulletin have stated that with the increasing size and complexity of international disputes, experts will be called upon more and more to provide invaluable expertise and wider capabilities, and all involved should work to ensure that this expertise is utilized to its fullest extent. This expertise...
But counsel, isn't there a big difference between counsel, exclusion of counsel, and exclusion of experts, as additional counsel must be approved by the tribunal? So it's a question of withholding approval and not exclude. So isn't that a big difference?
Article 18.4 addresses the tribunal can withhold approval of a suggested change in counsel. Here, I would suggest that a change is no different than an introduction of an expert, or by analogy, the counsel.
But a witness does not have to be approved by the tribunal, is that correct?
That is entirely correct, Madam Arbitrator, and thus this tribunal would be the first to hold this. However, given the growth of experts and their importance in increasingly technical international commercial arbitration, this tribunal should exercise that. And I would note that the risk here is that respondent has refused to waive its challenge to arbitrator burden as requested by claimant, and has stated that it will hold Ms. Burden under close scrutiny. I would suggest that, and I see my time is expiring, may I take an additional minute to conclude on this issue?
Yes, please.
Thank you. I would suggest that this close scrutiny implies a high likelihood that respondent will, in fact, challenge arbitrator Burden for the ongoing litigation between arbitrator Burden's husband and Professor John, which we see from page 48 of the record will be decided during the pendency of these proceedings. Thus,
But counsel, can respondents still challenge Ms. Bourdin due to the relationship between her husband and the expert witness?
Madam Arbitrator, it is correct that the time has lapsed for a challenge based on the facts before this tribunal under LCA Rule 10.3. However, any new facts that could arise, in particular related to the decision of the court case at hand, could create new grounds for a challenge. And a challenge would delay...
Well, the behavior of Ms. Bourdin could create new grounds for challenge. That is for sure. For example, if she were to insult one of the parties or one counsel, that could create a new challenge. And you wanted to respondent renounce of this possibility to challenge an arbitrator for obnoxious behavior?
Madam Arbitrator, we would suggest that respondent either make a limited waiver of their right to challenge arbitrator Burden for these particular circumstances involving the litigation, or that this tribunal exercise its power under LCI Rule 21.1 to appoint a tribunal-appointed expert instead of Professor John, if in fact what respondent or the complexity of this case requires an expert witness on this matter. I would note that a challenge would create a delay sufficient that claimant's requested award of replacement goods by the September agreed upon inspection would be unfeasible. Thus, this tribunal should exercise its discretion and exclude Professor John. Thank you.
Thank you very much. Any questions by my co-arbitrators?
No, thank you, Madam Chair.
No, thanks.
Thank you. Then we move on. Counsel for respondent, the floor is yours.
Members of the tribunal, my opposing counsel raised 3 points on this on the inclusion of Professor John, and I will be addressing all 3 of them in turn. Members of the tribunal, before we move on to the arguments, if in a nutshell, if we were to look at the claimant's case for the exclusion of Professor John, we see that they request his exclusion based on an assumed conflict of interest, not with the claimant-appointed arbitrator, but with the husband of the claimant-appointed arbitrator in a dispute that has absolutely no correlation to the one at hand. As such, members of the tribunal, we do not see any conflict of interest between Professor John and Mrs. Burdin for the simple reason that if we look at the LCIA rules, although they are silent on the issue of conflict of interest with regards to a party appointed, with regards to an expert and an arbitrator, we see that there are no possible grounds for the challenging of either of these 2 parties with regards to a conflict of interest. And even if this tribunal were to refer to soft law principles, such as the IBA guidelines on the conflict of interest, which this tribunal may do by virtue of Article 22(1) Clause 6, we see that even in that instance, Article 3.3.7 cannot be invoked because there can only be a conflict of interest between an arbitrator and a legal counsel. And this relationship as an expert and a legal counsel is very distinguishable because of the fact that a counsel appears on behalf of a party to further their stance on a matter of the case. An expert witness has a duty and owes a duty to this tribunal to present an objective report on a highly technical matter such as the one we have today. Therefore, members of the tribunal...
Counsel, you have been citing the IBA guidelines, and isn't there a clause talking about enmity between an arbitrator and an expert that might create a conflict?
Madam Presiding Arbitrator, the provision that you are referring to is in fact Article 3.3.7 of the IBA rules. However, that only gives us a distinction between a conflict of interest regarding an enmity between an arbitrator and a legal counsel. Professor John does not fall within the scope as he is a party-appointed expert here to present a highly technical expert report on the merits of this case, Madam Arbitrator, and as such is not applicable today. With regards to my opposing counsel's submission that Article 18.4 may be extended by analogy, we do not see this as the case because if we were to refer to the drafting history of Article 18 in the 1998 LCIA rules, while this was a broader version, we see that the current version of the LCIA rules in Article 18.4 cannot be extended to a party-appointed expert for the very simple reason that it was included, and as was stated by Professor Maxi Scherer and Lisa Richman in their book on arbitrating under the 2014 rules, that it was in response to the Hrvatska versus Slovenia problem in order to prevent a conflict of interest between a counsel and an arbitrator. Therefore, members of the tribunal, we do not see this provision applying even by analogy due to the fact that they serve two very different and distinguishable roles in these proceedings today. With regards to my opposing counsel's final point on the challenge to Mrs. Burdin, we do not see any need, as although my client did in fact reserve their right to challenge Mrs. Burdin, we do not see that my client would invoke this right to challenge Mrs. Burdin, as there is no conflict of interest here today, members of the tribunal, and thus we request the inclusion of Professor John, as he is the only suitable expert to give this tribunal an objective report on the comparison of the Greenacre and Riverhead tidal power plant turbines, as he is an expert well known in the fields of cavitation and corrosion and has prior experience working at the Riverhead tidal power plant. And because of that, we see that although there are alternative experts out there, Professor John is the most suitable to this case, as he would provide an objective, in-depth analysis to this tribunal on the merits of the case. And as I see I've reached my allocated time limit, I would like to conclude by respectfully asking this tribunal not to order the exclusion of Professor John. Thank you very much for your time.
Counsel, sorry, one question. You heard the proposal that we appoint an expert, in particular in light of the time restrictions we have presently here. Would that be an option for you, that we say, okay, none of the two parties has their party-appointed expert?
Mr. Arbitrator, the respondent would be open to that proposal if one of those experts are not Professor John, as even in the event he's appointed as a tribunal-appointed expert, we do not believe that, apologies, members of the tribunal, we see this as a feasible solution because even if Professor John were to be appointed as a tribunal-appointed expert, his verdict would be objective and the same.
Yeah, but any other tribunal-appointed expert apart from Mr. John? Would that be an option for you?
Mr. Arbitrator, we see that even if the tribunal were to appoint their own expert, they should choose and select Professor John, as he is the most suitable one to present the tribunal with the merits of the expert report on the turbines.
Okay, thank you.
Thank you. Any further questions?
Just a very brief question. You've argued, counsel, strongly that there is no conflict of interest that should concern this tribunal as regards Professor John. You're presumably content that the fact that Professor John and the spouse of one of the members of the panel are in an argument is not going to influence that arbitrator when considering the testimony of Professor John. I mean, that's a point you will have taken account of, because in a sense it's a point that would go against your side, is it not?
Mr. Arbitrator, if we look to page 40 of this record, we see that Mrs. Burdin herself has disclosed to all parties that the disputes at hand, the dispute in the patent litigation and the dispute at hand have absolutely no correlation to each other. And because Mrs. Burdin and Professor John are to be held to the standards of independence and impartiality, we do not see this would affect her ability to give an objective judgment in this case.
Yes, I'm encouraged that your position is that you don't see this impacting on the impartiality of the tribunal. Thank you.
Thank you very much. Now we turn to counsel for claimant for rebuttal, please.
Thank you, Madam Presiding Arbitrator. Claimant 2 is confident in the independence and impartiality of this tribunal. We are worried about the risk and the delay that could come with a potential challenge. And we see from LCIA reference number 111947, a challenge decision rendered on 4 September 2012, that LCIA, the former vice president of the LCIA court, rendered his decision based on Article 3.2.1 of the IBA rules orange list. As stated by counsel for respondent, this situation involves the Article 3.4.7 of the IBA orange list, and thus the risk of delay is real. Thank you.
Thank you. Counsel for respondent, please.
Members of the tribunal, we do not see that there would be a delay of proceedings for 2 reasons. Firstly, my client's right to invoke their right to challenge Mrs. Burdine has expired, and even if it hadn't expired and extends to these proceedings, we would not invoke it because there is no conflict of interest to challenge Ms. Burdine on.
Thank you very much. Any questions from my 2 co-arbitrators regarding the procedural issues?
With apologies, Madam Chair, just a very quick intervention. In your last remark, counsel, for the claimant, you referred us to an LCIA court challenge decision. You didn't give us much in the way of detail. Do I take it that that challenge decision related to the appointment or removal, exclusion of an expert, or was it an entirely unconnected matter? When I say unconnected with the issue in hand.
Mr. Arbitrator, it did not specifically involve the question of expert witnesses. It involved a party's challenge to an LCIA appointed arbitrator whose law firm in Dubai accepted representation, a very tangential representation of one of the claimants, and they made their ruling on the basis of 3.2.1 of the orange list, which states the arbitrator's law firm is currently rendering services to one of the parties or an affiliate without creating a significant commercial relationship or involvement of the arbitrator.
That's great. Thank you for the clarification. That does it. Thank you.
Thank you. Any further questions? If this is not the case, we turn to the merits of the case. Counsel for claimant, the floor is yours.
Good day, members of the tribunal. My name is Tariq Malouf, appearing on behalf of claimant Hydro EN in these proceedings. Claimant paid a 10% premium for respondent's R27V Francis turbines, in part because the unique steel alloy used would allow for the longest possible inspection and maintenance intervals. However, respondent delivered uncertainty. Uncertainty as to whether the turbines were constructed with the correct quality of steel, and uncertainty as to whether the turbines can operate with minimum downtime. Thus, we have 2 submissions to this tribunal. First, that the respondent fundamentally breached the sales agreement by delivering non-conforming turbines under CISG Article 35. And second, that under CISG Article 46.2, claimant is thus entitled to delivery of 2 replacement turbines. We begin with the question of non-conformity under CISG Article 35, and we advance 2 independent rationales for non-conformity. The first is that the suspicion of the quality of the steel used in the turbines renders them not of the quality agreed to under the contract, and thus non-conforming in the sense of 35.1. And second, that this suspicion has further impeded their particular purpose under Article 35.2b. Turning first to Article 35.1, we recognize that the majority of courts do not recognize that suspicion alone is sufficient to find a breach.
Counsel, I have a question. Where do we get the requirements from the contract? What was required under the contract? You're just starting with some suspicions, but I do not know what was required under the contract.
Madam Presiding Arbitrator, I would point the tribunal to the record at page 11.
Yes.
Clause 2.1b, the seller's obligations, that they were to produce and deliver to the buyer 2 of its newly developed Francis turbines of 300 megawatts power each, with the further characteristics as specified in detail in Annex A. We posit that Annex A is where the requirement for steel quality is held, because in the record at page 28 for arbitration, I apologize, in the respondent's response to the request for arbitration, They state in paragraph 15 that the mere fact that it cannot be excluded.
Could you please indicate the page of the record?
Page 28, Madam Presiding Arbitrator.
28.
Paragraph 15.
Yes.
That the mere fact that it cannot be excluded that the turbines may have been produced from a charge of steel that has not been properly examined and is not in line with the required specifications. Those required specifications referenced by respondent, we imply to reference the quality of the steel, as that is the alleged nonconformity that they were responding to in that clause. Does that adequately answer your question?
Well, I have some concerns relating to Article 22, para 2 of the contract, the entire agreement clause. You're not referring to the contract itself, rather you're referring to evidence outside of the contract, aren't you?
Madam Arbitrator, the Annex A should be considered to be a part of the contract, as it's specifically referenced in Article 2.1b, where it's stated that not just that 2 R27V Francis turbines must be delivered, but that they should be as specified in detail in Annex A. Annex A is not provided as part of the competition materials. However, we believe it's reasonable to assume from the record that we can interpret these terms to mean that the quality of the steel was agreed upon by the parties in that annex.
Thank you.
Having hopefully established that the quality of the steel was a contractual term which seller agreed to, we would point out that while many courts have not found that suspicion alone is sufficient to find a nonconformity of goods, as Professor...
So may I just interrupt you, counsel? So you are not relying on actual nonconformity. You're just saying there's some suspicion, and a suspicion should be treated like a nonconformity, like an actual nonconformity, but you're not relying on actual nonconformity of the goods.
Madam Arbitrator, in our argument for nonconformity under 35(2)b, that the requirement for an early inspection...
Now we're talking about 35(1) now. The quality of the steel, the features of the steel itself.
Correct, Madam Arbitrator. Solely within the confines of our 35(1) argument, we cannot argue that the steel actually is not of the correct quality, because the only way that the quality of the steel can be determined is through an extensive investigation.
Well, I have been wondering, what is the standard of proof that we were to apply to decide whether goods are non-conforming?
Madam Arbitrator, Professors Charles Katubi and Luke Sabatka in their General Principles of Law and International Due Process explain that the standard of proof before international tribunals is that...
May I just ask you, is the standard of proof covered by the CISG? Because you're now relying on some international principles.
Madam Arbitrator, that is a topic of discussion amongst experts in the field of the CISG.
What is your position?
My position is that of Professor Harry Fleckner, that the CISG does not cover questions of the standard of proof, and that in this sense, we must look to the reasonably convinced standard. I would also point out that Professor Seidov in an article titled Article 35 of the CISG, reflecting on the present, thinking about the future, states that he comes to the contrary conclusion that the CISG does govern the standard of proof, and then references Professor Albert Kritzer in his book Reasonableness, stating that reasonableness is specifically mentioned in 37 provisions of the CISG, which we believe should lend additional weight to the idea that this standard of reasonably convinced, which Professor Katubi explains is functionally the same as preponderance of the evidence.
Actually, that was also the position of the CISG Advisory Council, to say that first CISG covers and second reasonable. So, question to you, counsel. Well, what does that mean as regards the actual non-conformity of the goods?
As regards the actual nonconformity of the goods, Madam Presiding Arbitrator, I would point you to page 55 of the record, establishing that both parties have stipulated a 75% likelihood that the steel used in the turbines is not conforming and thus will require some degree of repair or replacement. That 75% threshold, we believe, should satisfy the reasonably convinced standard laid out by the CISG or General Principles of Law. I'd point out that the CISG Advisory Council opinion that I believe you're referencing, Advisory Council Opinion 6, does reference the reasonable certainty standard in relation to calculation of damages, and not specifically nonconformity under Article 35, which is the only reason that I stated that the
Thank
CIS...
you. So you're now switching, counsel. I heard you say that that it's reasonable to infer that the goods are not of the quality that was called for under the contract?
Madam Arbitrator, that has always been our position, that the suspicion of goods is the theory of nonconformity, and that the standard for applying that theory is reasonably convinced suspicion. For instance, we would not propose to this tribunal that if there were a 1% chance that the turbines were produced with the incorrect quality of steel, that alone would be sufficient to find breach under CISG Article 35. However, under this idea of the reasonably convinced preponderance of the evidence, or simply greater than 50% standard, we believe that in the facts present here today, where there is a 75% chance that the delivered goods were not created with the correct quality of steel, that standard is satisfactorily met.
Could I just interject very briefly, if I may, with two questions just for clarification? We have two turbines under this contract, and as I understand it, it may be that those two turbines were not manufactured using the same steel, whether or not that steel was defective. Does that in any way improve the odds or worsen the odds of both turbines being defective as a result of defective steel? That's the first thing. And the second thing, which is linked to it, the provisions at Article 19 concerning liquidated damages talk about the turbines operating to a capacity of at least 60%, as I understand it. Do we understand that in the event there is some defect in the steel, they will be completely non-functioning, or is it more likely that they will function to a level that may indeed exceed 60% of the capacity, which appears to be something that is contemplated by the contract when it comes to a decision on liquidated damages payable? I'm sorry, that was a rather long question. I don't know whether you caught both of those bits.
Mr. Arbitrator, I'll begin by addressing the question of the performance of the turbines. The performance of the turbines would speak to their nonconformity under Article 35(2)(b). However, under Article 35(1), even if the turbines function properly, they could still be of the incorrect quality or description in the contract, and thus be nonconforming in that sense. If, in fact, their performance did not meet the contractually required levels, then they would also not be fit for the particular purpose of the contract, 35(2)(b) nonconformity. However, each of those individual nonconformities is sufficient to find a breach. To your question about the probabilities of a single turbine being affected, we've calculated that there is a 35.7% chance that both turbines were affected. You're correct in stating that each turbine is made from a separate batch of steel, as stated on page 51 of the record. And we know that 70% of the steel that respondent uses comes from trusted quality steel, and that during the relevant time, they made 10 turbines, 2 of which were defective and were used at the Riverhead plant. So we know that only 3 of the 8 remaining turbines are actually conforming and created from the correct quality of steel. And thus we calculate the percentage chance that at least 1 turbine was affected is at 89.3%. And we point out at this time that we believe that that risk of nonconformity should rest with respondent, in large part because they failed in their informational duties to inform us of qualities of the turbines which, as stated in Professor Schwenzer's article, that the seller is generally under the obligation to bring the buyer's attention to all features of the goods that could potentially affect the buyer's decision to buy them. Respondent was aware of the fraud at trusted quality steel a full 2 weeks before the beginning of the inspection test in September of 2018, and chose not to inform claimant of this fact. Had they done so, we could have, under CISG Article 47(1), permitted a knock frisk during which they could confirm or falsify the proposition that the turbines were created with the incorrect quality of steel. However, by delivering the turbines and failing to inform my party claimant about the problems at trusted quality steel, they now force us in a position where we come to arbitration with no ability to inspect the turbines ourselves, as that's not the function of our company, and thus forcing us to rely on a suspicion of the goods theory to substantiate nonconformity. Have I answered both of your questions? Thank you.
Yeah, thank you.
So these are our submissions on nonconformity, that Article 35(1), the quality standard is not met because of the quality of the steel, and Article 35(2)(b), which I don't believe I've addressed as thoroughly as I would like, that because, as agreed to in the contract on page 12 of the record, Article 2Ds under seller's obligations, that the first inspection should be performed in the third year. We know, as a recommendation of CEO respondent, that in fact we will be required to inspect the turbine in the second year.
Council, I would be very much interested if you could address the second question, namely, your party is claiming delivery of substitute goods. So, what are the prerequisites for this?
Madam Arbitrator, the prerequisites for a 46-2 request for delivery of substitute goods are first, that there is a nonconformity. Second, that nonconformity is fundamental. And third, that we provide adequate notice to the respondent in this case that we would like replacement goods.
Council, I would, before you address all the other questions, I'm worried about one clause in the contract that you already mentioned when we discussed the validity of the arbitration agreement, and that is the limitation of liability clause. And I saw that this limitation of liability has a cap, an overall cap. The overall liability is limited to $20 million US. Is that correct?
No, Madam Arbitrator, that is only slightly incorrect. In fact, the overall amount of damages liquidated in actual is limited to $20 million. However, we are not, we will be requesting damages for a downtime due to nonconformity of the goods under
Yes, okay.
And that,
maybe you let me finish my question. How much does it cost to manufacture 2 new turbines for respondent?
each turbine costs $14 million to produce, so 2 of them will require $28 million.
So that's $28 million. And we do have an overall cap of $20 million, correct?
Correct, Madam Arbitrator.
So if respondent chose to sit idle and do nothing, that would mean it would be liable in damages, correct?
If the turbines are unavailable for the production event,
Yes. If respondent, even if we were to decide that respondent is obliged to the delivery of substitute turbines, if it wouldn't do it, the consequence would be damages, correct?
Correct, Madam Arbitrator.
Yeah, and then the cap would apply, 20 million. So how do you reconcile the fact that a delivery of substitute goods would cost respondent 28 million, whereas it contracted for an overall cap of 20 million?
Madam Arbitrator, we would put forward the theory that if respondent wishes to argue, I see that my time has elapsed, may I answer your question?
Please answer the question, yes.
If respondent advances a theory that they've somehow derogated from the provision of the CISG, allowing us to request replacement goods, that the appellate court of Linz, Austria, has stated that a mere hypothetical intent of the parties to derogate is insufficient. Instead, a real intent needs to be determined, and specifically, that the party relying on exclusion of the CISG's applicability bears the burden of proof. And so if they wish to state that they've excluded the possibility of replacement goods in spite of the fact that that's not mentioned in the sales agreement, I would put that it's their burden to prove this. And I'd additionally point out that respondent only negotiated.
That was not really my question. My question was not, does this limitation of liability clause exclude other remedies that could be available under the CISG? My question was, how does this cap on limitation of liability influence a possible remedy that would be much more expensive for the seller than its liability contracted for under the limitation of liability clause?
I apologize, Madam Presiding Arbitrator. I suppose my direct answer to that question would be that the limitation on liabilities clause and the request for a remedy of any kind, which in dollar terms would cost more than $20 million, or in this case, like ships passing in the night, they apply to different systems of remediation for the contract. And that if respondent is concerned about bearing the burden of producing 2 turbines costing $28 million, that their remedies are in turn on page 52 of the record, paragraph 36, to attempt to resell the turbines for use in other projects, which the record states that they could easily be done, albeit without reaching their optimal output, or on the subsequent page 53, paragraph 42, to seek indemnification from their supplier, Trusted Quality Steel.
Okay, thank you. I think
the time is up. Yeah.
Is up.
Yeah.
Do my 2 co-arbitrators have further questions for counsel for claimant?
Just a very brief intervention, if I may, and I think the answer may already have been given, but for my own clarity, we are saying that we don't know whether or not the defective steel is being used. The turbines might be in perfect working order and they may run their 40-year life. If when the inspection is carried out that proves to be the case, is claimant satisfied that the expense and time that the respondent would have been put to will have been warranted? In other words, is this the opportune moment for putting in this particular claim, bearing in mind that at the present time it is not known whether the turbines might be in perfect order? Have you started your complaint too soon? Is my question.
Mr. Arbitrator,
too soon. Yeah.
I'm sorry, I didn't catch the last part of
you brought your complaint too soon. Was the question.
Mr. Arbitrator, our position is that we have not brought our complaint too soon, and then in requesting replacement turbines, what we're attempting to do is essentially get what we bargained for under the contract, 2 turbines which wouldn't have to be inspected until the 3rd year. In delivery of the turbines, the mere suspicion of the goods, even if they turn out on inspection to be physically flawless, will still have impeded their intended use, because if we had purchased the cheaper, remember we paid a 10% premium for these turbines, if we purchased the cheaper turbines with the standard inspection intervals, we would have been in the same position. And so we will have been in a position, regardless of the actual quality of the steels, of not having got what we bargained for in the contract.
I understand your point.
Thank you very much. Stefan?
No questions from my side. Yeah.
If there are no further questions, then counsel for respondent, please.
Good morning, good afternoon, or good evening, members of the tribunal. We've said it once and we'll say it again. The remote possibility of a defect is something completely different from an actual defect.
Forgive me, counsel, I'm so sorry to jump in so quickly. Just remind us, please, of your name. I don't see it immediately on the screen. I'm so sorry.
My name is Tiranya Aberatna, and I will be representing the respondent, Turbina Energia, as a substantive speaker today, while I will be mirroring the submissions made by my opposing counsel. Members of the tribunal, counsel for claimant came forward today and made a submission that first, the turbines were non-conforming under Article 35 of the CISG, and they would be entitled to the remedy of replacement under Article 46(2). But I firmly contend those claims, and I bring forward 2 submissions for this tribunal today. First, the turbines are conforming under Article 35 of the CISG, and second, the claimant is not entitled to the remedy of replacement under Article 46(2) of the CISG. Members of the tribunal, under my first submission, I will be addressing the claims brought forward by counsel for claimant in terms of Article 35(1) of the CISG. Counsel for claimant failed to actually provide us with conclusive proof that Annex A actually contained quality requirements of this contract. They failed to recognize or appreciate the presence of this entire agreement clause found on page 13 of the record under Article 22. And it is our submission that the counsel for claimant cannot supplement or contradict terms in this contract. And even if in the event our Annex A contained quality requirements of these turbines, it is not in breach. When we look at the claims brought forward by counsel for claimant, they said that firstly, the standard of proof they would be using, that it has to be reasonably convincing that a suspicion would amount to a nonconformity. And the proof they relied on was that first, there was a 70% chance that the steel used was that our main supplier, Trusted Quality Steel, provided us with 70% of the steel used.
Counsel, I have a question. Is it your position that it is claimant who bears the burden of proof?
Yes, Madam Arbitrator, it is our position that the claimant bears a burden of proof in this instance, because when we look at the principle of rule and exception, we see that it is the claimant who bears the burden of proof as they brought forward this claim.
Yes, I am a bit worried, counsel, because under normal circumstances, claimant could carry this burden of proof and could prove the non-conformity of the goods by relying on documents. We would have document production in this arbitration, and then we could see, does the steel come from respondent's fraudulent supplier or not? If it had seen probably the documents before, and it would have been clear that the steel did not come from respondent's fraudulent supplier, then we wouldn't be in this arbitration. So it's just because we don't have the documents, and claimant is not really in a position to prove by relying on these documents the non-conformity of the steel. So I have been thinking, as it is in the sphere of risk of respondent, that it cannot produce the documents on which claimant were to rely. Shouldn't we shift the burden of proof?
Madam Arbitrator, in answering your question as to the issue of the certification of the steel, we see that claimant did not request actual certification of what steel was used. And secondly, when we look at the issue of our client relying on our supplier to provide us with steel, we see that the lack of certification is due to a fraud, which in fact does not conclusively prove that all charges of steel that we got from trusted quality steel are non-conforming. If I may direct this tribunal to page 14.
Counsel, the question whether the steel that was used in the two turbines came from your client's fraudulent supplier, these documents were with respondent, weren't they? Originally.
Yes, Madam Arbitrator, we had the certification that we received from our supplier, but from that certification alone, even if we had it, it would not be possible to confirm or deny whether or not the charges of steel used in these turbines were non-conforming. First, as trusted quality steel was not only our single supplier of steel, there is a possibility that the turbines from Greenacre could have been produced using other suppliers. And if we look at page 14 of the record, which is a newspaper article that discusses the fraud that was committed by trusted quality steel, if I may read out the relevant portion to the tribunal. It sets out, according to the prosecution, Mr. Madoff issued at least half of the certificates for the steel charges of trusted quality steel without having made the necessary examination. What we understand from this is that first, issuing charges of steel without examination is very different from having examined the steel. The steel was proven to be non-conforming, and that certification was forged to actually read that it was. This is very different. And further, when we look at the standard of at least 50%, that means that there is a possibility that the charges of steel are actually conforming even if they came from trusted quality steel, which completely negates the point counsel for claimant brought forward, which was that just because trusted quality steel provided us with 70% of our steel does not render a suspicion amounting to a non-conformity. And it does not amount to a reasonable convincing point as to why a suspicion would amount to a non-conformity.
So what is your position about shifting the burden of proof? We are now not talking about the standard of proof. We are now talking about the burden of proof.
Well, Madam Arbitrator, when we look at the burden of proof, we can either look to the principle of rule and exception or the principle
of... I think we all agree on that. But as regards the document that had been in your client's possession and that are no longer available, could that lead to a shifting of the burden of proof? So that it's now your client who has to prove that at the time of the passing of the risk, the goods had been conforming to the contract?
Well, Madam Arbitrator, even if our client had all certification, it still would not be able to shift the burden of proof because that certification would not be able to tell us whether or not that those charges of steel were conforming first because of the fraud. And if I may direct this tribunal to procedural order number 2. question number 25 on page 50 of the record. This question is in regards to the loss of information by our client.
Yep.
Yes.
And if I may read out the relevant portion, on the latter part of the answer to this question, it sets out, however, as reports had been forged by trusted quality steel, it cannot be excluded that it still would not have been possible to determine whether or not the particular charge had been examined or not. As such, we see the burden of proof still lies with the claimant as they brought forward the claim, and they are in fact control of the goods, which are the turbines, and by both the principle of rule and exception and the principle of proof of proximity, they bear the burden of proof in this instance.
Thank you.
For the members of the tribunal, when we look at, as such, we see that the counsel for claimant's point on Article 35(1) of the CIC does not stand, as we see that all charges of steel were simply not examined. That cannot exclude the possibility that the charges of steel were conforming. Second, we do use other suppliers other than trusted quality steel, and as such, we see that this point does not stand. Further, members of the tribunal, counsel for claimant brought forward the point that 37.5% or 89.3% of the turbines were actually non-conforming. But that point is actually incorrect on fact when we look at the issue of the construction of these turbines. When we understand the construction of a turbine, we first have to look at the supplier. While I proved earlier that just because these charges of steel came from trusted quality steel or any other supplier that our client had does not render them non-conforming. Simply they were not examined, and there is a possibility they can be conforming, and it is not enough to render suspicion to amount to non-conformity. And so, second,
in your opinion, counsel, what is the probability that the steel is non-conforming? Claimant spoke about of 75, 89%. So what is your position on this question?
Well, Madam Arbitrator, in regards to this case, we see we are unable to actually give a probability or percentage value due to the very intrinsic and very complicated nature of this case. There was a fraud, certificates were not, charges of steel were not examined, and certificates were forged. And as such, we cannot simply state, as counsel for claimant did, that simply because trusted quality steel provided us with 70% of our steel, that 70% was used over multiple periods of time for the construction of multiple turbines. Counsel for claimant directed us to page 51, question 29 of procedural order number 2. Here we see that that is simply not the case because each turbine is constructed with a separate charge of steel, and that separate charge of steel could have come from any one of our suppliers, members of the tribunal. And as such, we see counsel for claimant's calculations of that percentage value that the turbines are non-conforming are incorrect in that sense. First, these turbines were constructed at various different periods of time, which means there were different charges of steel from different suppliers that were used. And even if it was trusted quality steel the steel was used in was from trusted quality steel, it does not amount to a non-conformity. As such, we see there is no breach of contract under Article 35(1) of the CISG or under Article 35 of the CISG. As first, the turbines have been operational since their installation in the power plant. They passed the acceptance test. They are providing the relevant output, and they have gone through multiple peaks of high demand, and there has not been a dip in the energy since then. And as such, we see we cannot simply state that they are non-conforming based on mere suspicion, which counsel for claimant failed and could not substantiate. Moving on to my second submission, members of the tribunal, counsel for claimant argued that they would be entitled to replacement under Article 46(2) of the CISG. However, they failed to meet any of those requirements. Article 46(2) of the CISG requires that first, there be a fundamental breach of contract, and second, sufficient notice specifying the nature of that nonconformity must be given under Article 39 of the CISG or a reasonable time thereafter. Members of the tribunal, the claimant does not satisfy any of these requirements. When we look at the concept of fundamental breach in terms of Article 46(2) of the CISG, we see that that standard is actually elevated. We first must understand that there must be a substantial deprivation, and that the defect cannot be cured by repair. If I may quote the commentary on the CISG under Article 46.2 of the CISG, it sets out that first there must be a substantial deprivation within the meaning of Article 20.
Council, but the parties themselves have specified in their contract what they think is a fundamental breach of contract. Wasn't the threshold for fundamentality of breach lowered in the contract?
Yes, Madam Arbitrator. When we look at procedural order number 2, question number 4, it sets out that the parties merely lowered the threshold. And when we look at Article 6 of the CISG, it sets out that the parties can either derogate or vary the effect. And we hold that this was a varying of the effect of Article 20 of the contract, which is termination for cause. And when we look at the operation of the concept of fundamental breach within its own, within the overarching principle or contractual provision it is used under, there are various standards that also are applicable to that. For instance, if we look at Article 46.2 of the CISG, that relevant standard of fundamental breach has an additional layer which sets out that the goods cannot be, if there is fundamental breach, only if the goods cannot be repaired. That is different from the standard of fundamental breach using avoidance.
Excuse me, Counsel, where can I find that in the wording of Article 46.2? That there's only a fundamental breach if the goods cannot be repaired.
Well, Madam Arbitrator, it's not, as I see my time is elapsing, I will answer your question. If I may request an additional 2 minutes to conclude my submission and answer your question. Thank you. Well, Madam Arbitrator, when we look at Article 46 of the CISG, we see that it does not, the wording itself does not contain that there is fundamental breach only when there is no remedy available to cure the defect, that it cannot be cured by repair. But when we look at the commentary on Article 46.2 of the CISG, we see that first it sets out...
Which commentary? Is there an official commentary?
Yes, Madam Arbitrator, it's a commentary that was actually written by Professors Schlechtrim and Schwenzer in terms of Article 46.2 of the CISG, which sets out that the standard of fundamental breach must first be substantial deprivation, and second, it cannot be possible to cure the defect by repair. And as such, we see that in this instance, the claimant fails to meet any of these requirements. They have not been deprived of what they expected under this contract, which was 2 turbines that provided 600 megawatts of energy each, which the turbines do meet this requirement as they are operational. Since their installation, they are providing the required output, and the claimant is consistently profiting off the sale of energy since the operation of this plant. Further, members of the tribunal, in terms of the possibility of repairing these turbines, we see that under the commentary itself, it sets out that when we look at machinery or machinery used in power plants, that there is a likelihood that these goods can be repaired, and as such, it would not amount to a fundamental breach. And as such, we see there is no fundamental breach of contract. Further, when we look at Article 39 of the CISG, we see the claimant has not given sufficient notice, as merely assurance as to the quality of the goods does not amount to a nonconformity as per the organic barley case. And as such, I conclude my submission. First, that there is no breach of contract under Article 35 of the CISG. And second, the claimant is not entitled to request the remedy of replacement. And with that, I conclude. Thank you very much for your time.
Thank you. Do my 2 co-arbitrators have questions for Counsel for Respondent?
Not at this point from me, Madam Chair.
Not from me as well.
Thank you very much. Then we turn to Counsel for Claimant. You may now rebut these arguments by your opposing counsel.
Members of the tribunal, we informed respondent on 1 December of 2018 that only a direct replacement could exclude the risk of prolonged standstill, and requested 2 replacement turbine runners, which they declined. In the meantime, we continue to operate the turbines, just as we are required to under Article 77 of the CISG, requiring that a party intending to claim damages, which we will, has a duty to mitigate those damages. I would also point out to this tribunal that while we have been operating our turbines for 2 years without problems, so too did the turbines at the Riverhead power plant before the first inspection revealed that they were corroded beyond use. Thank you.
Thank you. Any questions?
Just for clarification on the question of the Riverhead turbines, I think it's on the record, is it not, that they were operated with salt water, not fresh water? Is that correct? You distinguish the two, do you?
Correct, Mr. Arbitrator. They were operated in saltwater.
Okay, thank you.
Counsel for respondent, do you have anything on rebuttal?
Yes, I do, Madam Arbitrator. Members of the tribunal, the 3 points counsel for claimant brought up have no standing here. First, in terms of their notice given on the 1st of December does not stand, as you have to actually specify the nature of the nonconformity under Article 39 of the CRSG, and merely stating a suspicion or the remedy you wish for does not suffice, as per cases such as the Pellets case. And second, when we look at the issue of damages, we see that Article 46.2 is actually built on the foundation of Article 46.1 of the CRSG that requires you cannot seek an inconsistent remedy such as damages, and as such claimant cannot claim for damages while seeking replacement. And third, in terms of the Riverhead power plant, we see they are incomparable to the Greenacre power plant, as it contained a tidal power plant, pump hydro power plant, and they contain very different circumstances. Thank you very much for your time.
Thank you very much. Any questions by my co-arbitrators?
No questions.
No,
from my
thank you,
side.
Madam Chair.
If this is not the case, I have a question to counsel for both parties. Did you consider to be treated equally during these proceedings?
Yes, Madam President.
Do you have any considerations about these proceedings?
No, Madam Presiding Arbitrator.
Thank you very much. And with this, I close our hearing, and we will expect your post-hearing briefs. Thank you very much.
Thank you all for your time.
Thank you.
Thank you very much, counsel, on both sides.
Also from my side.
Thank you all.
Thank you.
Okay, I'm going to now ask the